Hi everyone. Today we wanted to talk a little about some of the legal issues that you will face once in a while as commissioners. I want to start with, though, some guidance from the auditor's office. I know you received some information about a month ago saying that meals, cookies, things like that you might be doing at meetings or at banquets, dinners, that there may be some auditing issues with that. We're going to send guidance out to your conservation assistants so that you have guidance. The main thing is set a policy for your district on cookies, on meal costs that you pay for, and things like that so that you're covered. Set a policy, follow the policy. Today we have Eric Dearth with the Iowa Attorney General's Office. Eric, we really appreciate you being here to answer some questions for commissioners that they ask. And the first one is, what kind of services does the Attorney General's Office offer to commissioners and the assistant commissioners?
Yeah, well, thank you first for having me. So under Iowa Code, commissioners may call upon the Attorney General of Iowa for necessary legal services. And this means that after you check with IDOL staff and personnel, and they're unable to give you guidance about specific legal questions, you may contact the Attorney General's office. So there are generally three reasons you can end up talking to the Attorney General's office. First, there could be an occasion where you find that you have a question of statutory interpretation under the Iowa Code that nobody else can guide you on. Second, there may be a time where you have a legal procedure question, like, say, a lawsuit was filed against the district, or the district is filing a lawsuit. And perhaps the IDOL's personnel has not dealt with a specific issue, and then you can talk with us. Third, and probably most common, is with regard to contracts. So after using IDOL's support to draft a contract, you must get the AG's office approval. So this would include contracts such as Watershed Management Authority contracts, PL 566 agreements, subpoenas, etc.
Sure. Now, districts and the commissioners, the assistant commissioners, are protected as elected officials or appointed by elected officials. What does that protection entail?
Yeah, well, generally, this protection will allow for the Attorney General's office to represent the soil water conservation districts in their legal matters. So if the soil and water conservation district is suing or being sued, the AG's office may represent the district in the matter. Now, for the individual commissioners, when the commissioner is acting within the scope of his or her responsibilities and a lawsuit is filed against that commissioner, the state may step into the commissioner's shoes and become the defendant.
Good, good. Explain tort liability for us, and how does that protect commissioners and assistant commissioners, commissioners who are elected officials, and assistants who are appointed?
Well, tort liability, we hear that term a lot. It just means civil liability, or liability for negligent or wrongful act by a commissioner that would have caused a damage or an injury. And Iowa's Tort Claims Act protects the state and its commissioners from tort liability so long as the commissioner acts with due care within the scope of his or her duty as a commissioner. This due care within the scope of the position standard also applies to other state employees. Now, with regards to the volunteers, state volunteers also are not personally liable for their acts unless the acts involve intentional misconduct, are knowing violations of the law, or are for transactions in which the person gets an improper personal benefit. In other words, if volunteers or these assistant commissioners act with due care within the scope of their duty, they will also be protected from tort liability.
So how can the AG's office help a commission, a local district that has a soil loss complaint where the responsive party is not willing to implement something to solve the problem?
Mm-hmm. Well, when a soil water conservation district inspection shows excess soil erosion is taking place on neighboring land, and then that responsible party is just not cooperating, a soil water conservation can seek advice from the Attorney General's office for what to do next. The Attorney General's office can write a letter asking for compliance, or an administrative order can be issued ordering the landowner to comply. Now, if an administrative order is used and that party still will not cooperate and follow that order, the Soil Water Conservation District can then request the Attorney General's office to move forward and ask the district court to issue a court order requiring compliance.
Good. So they are backed up in their actions.
Yes.
Good thing, good
Especially when push comes to shove, when you use an administrative order, the administrative order will become enforceable in court. And so that's that step to ensure compliance.
Thank you. Can the AG's office assist a district in a maintenance agreement where the landowner is not following their maintenance agreement?
Yes. And actually, I just was working on one the other day. If somebody violates a maintenance agreement, the Soil Water Conservation District can follow a process to seek compliance or repayment. So the Attorney General's office can correspond with the landowner to find a remedy, or if necessary, the Attorney General's office will pursue that repayment in court.
Thank you. Thank you. Many districts own equipment and they rent it out, such as a no-till drill or something. Do they need to have insurance for that?
Well, soil water conservationists have statutory authorization to share and rent equipment to others. Unfortunately, there's nothing in the code that will get you a new no-till drill if the old one breaks. So in order to protect machinery or other personal property, insurance for equipment could be a wise decision. Now, if an accident occurs where someone is injured, the protections afforded under the Torts Claim Act would also apply to the Soil Water Conservation District.
Okay, thank you for that. What kind of liability then does a district have if they're having a field day, an educational event, and somebody trips or falls down? You know, how are they covered there? And maybe even not at one of their own farms or at a commissioner's farm.
Well, again, soil water conservation districts are covered under the State Tort Claims Act for acts or omission occurring within the scope of their job responsibility, so long as they're acting with that due care standard. And this can include demonstrational projects on public or private land, so long as the soil water conservation district gets the proper approval beforehand. Now, other Iowa code provisions limit liability for landowners of private land who allow for education or field days on their own land. However, the same protection might not be available if there's a failure to guard against dangerous conditions on the land, or if the landowner is charging a fee for the use of their land in the matter.
Okay. So that fee is key there. Thank you, thank you. Some districts do own some farmland as demonstration farms and things like that. Do they pay property tax?
I have good news. So if a soil water conservation district owns farmland or other real estate, that conservation district does not need to pay property taxes on that land. Even if the district is leasing out the property, the district is exempt from property tax. So you can save that money and put it towards protecting the soil and water resources of Iowa.
That's great, that's great. Eric, we really appreciate that. So if a district has a question, the best way to approach this, call IDALS. And if they can't answer it, you can.
Yep.
Thank you for that.
Yep.
Thank you. Folks, thank you for your work in conservation.
Thank you.